Okay, looks like we have counsel connected. So let's go on the record in IAT versus IAT. This is file number 2414662. If I could have both counsel put your appearances on.
Good afternoon, Your Honor. Vivian Atisha Howell on behalf of the plaintiff, Joe Ayat.
Jordan Broad on behalf of the defendant, Lindsay Ayat, who is, I looked as the DM Laronis on Zoom, I see.
Your Honor,
Okay.
I thought today was only the attorneys, so if you want, I can contact my client. Oh, there he is. Never mind. My client is on
That
as well,
Mr.
Your Honor.
Okay, that's Mr. Ayat. Okay.
Yeah.
All right, great. So we are just on the record for a status conference today. So Ms. Howell, on behalf of plaintiff, can you kind of give me an update on where the case stands and what we would need to do for scheduling going forward from your standpoint?
Absolutely, Your Honor. Right now we've been waiting for my client. We put a pause from mediation because my client was trying to work with his lender to figure out how much cash money he can get in order to do a full payout to Miss Ayat so that we could then make a suitable counteroffer because we were going back and forth in mediation and we were coming up with numbers. We just made today, right before the status conference, another offer. At one point, the parties had some kind of offer, but then I guess that fell apart. Some kind of agreement, should I say, and I guess it fell apart without the attorney's involvement. So now I've made a formal counter to the last offer that was made at mediation. That's where we're at. At one point I thought Miss Broad and I could have a stipulation on some things so that we wouldn't have to have additional discovery. But if anything, if we can't settle this case, and we are close, the numbers are close, I think that our offer is very fair and reasonable. And if we can't get a settlement, we are going to need some more additional time for discovery and possibly one more appraisal on the marital home and then proceed to trial, which I'm hoping we can all avoid because it's just going to cost the parties more than to litigate this than the amount that literally where we're at, like between us. So that's where we're at, Judge, if I'm making any sense, I hope. So the numbers are a lot smaller in difference between where they're at and where we're at versus the amount that it's going to cost both parties to settle this case or to proceed with trial on this case. So,
all right. So for purposes of today, what you would be asking for is just maybe another time, more time, maybe 30 to 60 days to continue to negotiate.
Yes.
Is that what you're asking for, Ms. Howell?
Yes, Your Honor, I am.
Okay. Ms. Ashyoung-Broad, what is your view of where things are at and what would you like to request?
Your Honor, this the complaint was filed in December. We mediated in August. We have been waiting from Mr. Ayat for over a month on a response to discussions that were had in mediation as to settlement. I have not reviewed the email that came from 118 regarding a offer, so I will go over that with my client today. And I do agree with Ms. Howell that we are close on numbers. We were close in mediation. It was kind of contingent on financing, as Mr. Ayat would prefer to keep the home and basically all assets. I do not believe we need more discovery, and I would object to the request for additional time. We have already extended the discovery once that we stipulated to, and there's an order in the court's file. We have had since December to do discovery. There's been extensive discovery in this case by both parties. So I believe that's inappropriate to get an additional time for discovery and would only delay this case and cost the parties more money. And so what I would request is the soonest available trial date that the court has. I think we would need a half a day or a full day. So even if counsel thinks we need a full day, I'd be in agreement to 2 half days. Basically, I really think we need the pressure of a trial in this case to get it settled because there has been a lot of delay.
Quick response, Your Honor.
Sure.
I think that just from a practical standpoint, the only delays have been the fact that my client has been working with the lender and trying to get the funds together. That's the delay. In terms of continuing with discovery, I'm going to just be honest to this court. I'm a practical attorney who's been practicing for quite a bit of time, unfortunately. I hate that I'm getting older, but it's what it is. And from a practical standpoint, I wanted to put a pin and a pause on discovery to see if we can just get this settled so that we don't have to work up these numbers, because it's going to cost these two so much more than where we are at the difference. And it just makes no logistical sense to be doing that. So if they can come together, that's great. If not, then we should be entitled to continue with our discovery, finish up the discovery, respond to whatever she needs, and then move forward in the same amount of time. And I don't have an objection to scheduling a trial date and allowing discovery to continue to a certain point before trial or whatever. But I'm just trying to be practical, Judge, because the numbers, the way they're adding up, I don't want to be running up a bill for a client and have all this work done, and then he settles at an amount that was like far less. It doesn't make any sense to run up a 20 grand bill if we're only 10 grand apart, kind of thing. It just doesn't make any sense to me. So that's why I'm asking for that. I'm just trying to be fair to both litigants right now. That's it.
Well, I mean, Ms. Howell, what information would you need if this were to go to a bench trial that you don't have? Like, I mean, what additional discovery do you need to do?
Honestly, Judge, I would just want time to be able to work with an expert, that I would have in mind for the valuation of the business, and then just have time to be able to get certain documents. My client, upon all the discovery that had been in a lot of it from opposing counsel that was sent over, and my review of documents, I found errors and had to address it with his CPA. So there's been some bookkeeping issues that my client has now been able to address, that people have not been doing their jobs for him. So the business has kind of been mismanaged, frankly, right? And so I need to get that in order and then have somebody be able to take a look at those numbers and then figure out what else we need to do. And that's the other thing. And there is a dispute as to the value of the marital home. The appraisals that came back are in dispute, and we would want to have a chance to at least have another appraisal on the marital home. We've already accepted the appraisals on the other stuff. I really wouldn't need anything more. I've already shipped out a subpoena to the opposing party's employment, and I've asked for her bank records and stuff, which haven't been provided, I don't think. So other than that, and I think Venmo statements, there's a subpoena that's that's outstanding to the plaintiff. But again, I would give her the same amount of time that I'm asking for. So I am not looking at more than another 30 days, 30 to 60 days, and then have a trial set so that the court doesn't go over its docket with the Supreme Court, which I'm well aware of. So I wouldn't want that either. But we just need some time to negotiate right now and see if we can just resolve this case. There's no reason why we're not resolving this,
May I respond to that?
Yeah.
The marital home was appraised by Mr. Iott by an appraiser of his choice. His now argument is that he doesn't agree with the appraised value because he doesn't believe it would sell for that amount, although he doesn't want to sell the home. So to have it reappraised is only going to cost more money. I have spent this entire case trying to come to compromises with opposing counsel, and sometimes we were able to. I asked her to pay for half the appraisal of the other two properties. That didn't happen until it was already appraised, and then he came back and said, can I have the appraisal? I'll pay for half. There has been so much discussion and negotiation, and there has, like I said, already been an extension of discovery. My client already went through the process and paid for an evaluation of sorts of the business. It's Mr. Iott's prerogative and choice not to have done so since December when this was filed. It is only going to cost more money to have additional discovery when we have had plenty of time to do so. So her argument that she needs more time is inaccurate because there's been plenty of time. Following mediation, there was a number of emails between counsel and I as she tried to argue that we agreed in mediation to extend discovery, which was not part of any agreement. We didn't sign anything in mediation. We informally agreed to put a hold on the outstanding discovery, and I was very frank with her and said, this does not mean I'm extending the discovery deadline. She knew that if she needed additional discovery, she had time to do that, and that date has come and passed. So to continue to delay this with additional discovery is completely inappropriate and is just going to delay the process.
I think it's inappropriate that opposing counsel is trying to make it sound like I requested the discovery.
Ms. Howell, I'm just gonna.
The first
I'm gonna
extension
cut you off
was
because none of
pursuant to
that.
her request. So,
I'm gonna cut you off because you guys can probably go back and forth for an
Yeah.
hour on each of your interpretations of what's happened, and none of that is helpful to me in terms of what we need to do going forward. So, I think there's two things at play here. Number one, Ms. Howell, it doesn't sound like really what you need is more discovery. It just sounds like what you're asking for is adequate time to prepare for trial and go through the documents that you need to go through. So,
right.
I don't really think, I think we're arguing about something that's really not even an issue. So I think a schedule that builds in time for the parties to negotiate and have time to prepare, yet still, get this resolved in a reasonable amount of time is what's appropriate. So what I'm going to do is, it sounds like one day was thrown out there. Ms. Howell, would you agree that one day would be enough time?
Depending on the experts and stuff, if we do have to bring them in for the evaluation of the business and, any other number of other individuals, I would say that just to be safe, Your Honor, we might need a 2-day trial. I don't anticipate it being a 2 full day trial, but I'd rather the court know that from now and not have that time reserved, and then we're like splitting the days far out. I would
Okay,
rather
so
say this
what
2
I'm
full
going to
days.
do is I'm going to set this for a 2-day bench trial. I'm going to set it for 90 to 120 days out. I think that should be enough time to give the parties an opportunity to continue to negotiate, and for both sides to go through what they have and be prepared. I will set it for a final status conference about 30 days prior to the bench trial date. If there is an agreement, we can enter judgment and take proofs at that time, or at any time prior to that. If the parties reach agreement, I'd be happy to set it for a final hearing earlier than that. But that'll give us one last opportunity to meet. If there is no settlement, then on that last date, we can discuss witness and exhibit lists. I'll give the parties, I always like to have trial briefs prior to a bench trial in a divorce case so that I have an understanding going in of each side's proposal for the division of assets and debts, and whether there are agreements on any matters at all, we can get those in place so that when we do get to the trial date, it's just going to be a matter of putting on proofs on the issues where there is a dispute. And that's how we'll go forward. So the court, again, will set it for a 2-day bench trial. I will send out notice of the date and time of the bench trial dates, as well as that final status conference. Again, if there's an agreement prior to that and the parties want to get on to enter the judgment, counsel can contact my office and we can get a date earlier than that. Ms. Howell, any other scheduling dates I can address for your side today?
No, Your Honor, thank you. I would just ask for clarification. If we do get a consent judgment to be put into place, do we need to file a motion for entry, or can we just schedule a pro-con hearing?
Yeah, just schedule a pro-con hearing. Ms. Ashioni-Brode, anything I can address for your side today?
No, thank you, Your Honor.
Okay, all right, so that's how we'll go forward. I will send out a scheduling order reflecting what we've discussed today. And thank you both. You're both free to disconnect at this time.
Thank you, Your Honor.
Thank you.
Okay, ma'am, are you Karen Garrison?
I am.
And sir, are you Charles? We'll go on the record in Garrison versus Garrison. This is file number 2514800. The record should reflect that both parties are connected by Zoom video for this hearing today. I have this set for entry of a judgment of divorce in this case. And Ms. Garrison, is that how you wanted to proceed today?
It is, yes.
Okay, and Mr. Garrison, is that how you wanted to proceed as well? All right, if I could have both of you raise your right hands, please. You both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, thank you. You can both lower your hands. I'm going to be asking you some questions here today. Ms. Garrison, most of the questions are going to be for you. But the questions I'm going to be asking you are those that I'm required to ask to establish the grounds for divorce under Michigan law. So my first question is, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
It is.
At the time that you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes, Your Honor.
Had you been a resident of Kalkaska County for at least 10 days?
Yes.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of the marriage relationship such that the objects of matrimony had been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you signed that complaint?
Yes, Your Honor.
Does that remain true today?
It does.
Are there any children under the age of 18 that were born to or adopted by you?
No.
Are you currently pregnant?
No.
Under the divorce today, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that?
I do, Your Honor.
And just looking at the proposed judgment here, it looks like both of you will just be keeping whatever personal property that you have, and you'll each be responsible for any debts that are in your own name, and that you don't own any real estate or real property. Is all of that correct?
Correct.
Okay, and then it also indicates here that there are going to be certain items that you would receive: a smoker, a rototiller, a wood chipper. Are those items, have those already been exchanged between the two of you?
They have.
Okay, all right, thank you. All right, and you're asking to have your last name changed, is that correct, as indicated in the judgment?
Yes, I'd like it changed back to Schuin, please.
Okay. All right, thank you. Mr. Garrison, have you been able to hear all the questions that I asked Ms. Garrison?
I have.
I think, Mr. Garrison, I don't know if you've got a microphone on your computer or whatever device, if you could get a little bit closer to that. I can hear you, but it's very faint.
That's what I'm doing, I guess.
Oh, that's way better. Whatever you did, that helped a lot. Okay, good.
So just a minute, I lost the picture, but I'll try to go back to it. There it is. Okay, is that better?
Yeah, much better. Okay, great. Thank you. Did you say that you have been able to hear all of the answers she gave to my questions?
I have.
And do you have any reason to believe that any of the answers she gave were untrue?
No.
All right. Thank you. And you understand that you also would not be receiving any alimony or spousal support, and that you would be waiving that forever as well?
Yes.
All right, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of the parties. the court will grant the divorce, and I'm signing that judgment here with today's date. That means that the divorce is final as of today. Ms. Garrison, that also means that your name is legally changed from today going forward. So you may need to get a copy of this judgment here at the clerk's office so that you can change your identification and other documents.
Thank you.
Ms. Garrison, yep. Ms. Garrison, do you have any questions at all?
No questions, Your Honor.
Mr. Garrison, did you have any questions? Okay. All right. Thank you. That's all for this hearing today, and you're both free to disconnect at this time.
Thank you.
Thank you. Okay, let's see. Ma'am, you're Clara Ernst, is that correct?
Yes.
And sir, you are Nicholas Ernst?
Yes, sir.
We'll go on the record in Ernst versus Ernst. This is file number 2514810. The record should reflect that both parties are present today by Zoom video. This is the date and time set for a scheduling hearing in this divorce matter. At this hearing, I usually just try to find out from the parties if there are issues regarding the division of any assets or debts of the marriage, or whether you've been able to reach any agreements. That helps me determine how to schedule the case going forward. So Ms. Ernst, as the filing party, have you been able to reach any agreements with Mr. Ernst on how to divide things up?
Yes. I'll
Okay.
be sending over the house to him, and then I'll be in there for another month, and I'll be leaving.
For the month?
Up to 6 if I want to. I'll be out on October 1st. Yeah, there is a judgment drafted, and I believe my attorney's going over it, and I will be sending that today, indicating that we'll both be taking what we came with and our own debts.
Okay. Mr. Ernst, what's your view on that?
What she's specifically referring to is signing a quick claim deed for the potential equity that she would have in the home that I purchased before we were married. Just to clarify that, and that's written up in the judgment. As far as the 6-month thing, that would only be if we didn't get divorced. What the reasoning behind that is because she managed to get me racked up with a domestic violence, so I can't go back to my house that I own. That'll be over in 6 months, though. So yeah, I don't know. In the judgment that was drafted, which I have not heard anything back on that, so I'm not sure what the status is. I've signed it already. I unfortunately don't have a copy handy with me, but I believe one may have been submitted to you. I can check on that when I get a chance to speak to the lawyer. Oh, awesome. So I'll have to speak to my lawyer then. Anyway, yeah, essentially kind of what she said there, where we, take what we came with. I'm not sure there's anything specifically in there that refers to debts incurred during the point of the marriage. It does exclude us both from debts the other may have incurred after the point of our separation. But once again, without, apparently any sort of record regarding this judgment, I'm not sure. I've signed it. That's all I can say at this point.
All right. So you're saying you did sign a judgment already?
I did, yes.
Okay. But you sound like you're not sure what was in that judgment.
I don't have it memorized, unfortunately. I don't have a copy in front of me. So,
all right. But
I'm fairly sure, but also I've been wrong before when I've assumed that I understood what a legal document said. So, that seems to be the purview of lawyers. And so I don't want to say, oh, I'm 100% certain, but it was explained to me at the time. I was fine with what was written in there.
All right. Okay. So you went through it. you signed it, so presumably, as long as it's the same document, we would be able to enter that judgment at a hearing that I could set within 30 days.
Which frankly, I would like as soon as possible. I mean, as far as I knew, we weren't really contesting anything. After the point of the divorce is final, then, you know, I can finally move forward.
Okay, all right, so, and Ms. Ernst, it sounds like you're pretty much on the same page. Is that a fair statement?
Yeah, I do have one question while never mind. Yes.
Okay. All right, so I will set this for my next available date. Whoever has that judgment will need that to be submitted to the clerk's office because I need to sign that. That's what finalizes the divorce, is the court signing that judgment. So I will need to have that prior to the date of that final hearing. So I will set it for the next possible date. It's probably going to be in about 30 days. I have 3 counties within my circuit, so I'm only in Kalkaska a certain number of days per month. But I will set it for my next available date. And then as long as that judgment is submitted prior to that, and then we can finalize the divorce on that day. The court will send you both notice of the date and time of that hearing. It will be by Zoom, just like we're doing today. Ms. Ernst, do you have any questions about that?
No, sir.
Mr. Ernst, do you have any questions?
No questions, though. Another 30 to 60 days. I may just, I can't afford the house while I'm not there. I've been paying for everything, including the utilities, this entire time. If Mrs. Ernst can cover some of the utilities, even that might help. But at this point, I'm losing money so fast that I am looking at having to put it up for sale almost immediately.
Ooh. In that case, then maybe we should talk about dividing it, because I think that maybe if we are going to put it up for sale, it makes more sense that we both get some of the equity. But no, I'm not moving out and I'm not paying your bills. I'm saving money to move
They
out of
aren't my bills. I'm not there.
I'm okay. I'm saving.
All right, all right, everybody, hold on. This isn't a time for the two of you to argue back and forth, so that's not what we're gonna do here today. I'm gonna set this for a hearing at my next available date. If you both have signed a judgment and we can move forward, then we will on that date. If you're still trying to negotiate over things, then we'll have to figure out where to go at that point, but.
I'm not allowed to negotiate with her.
That's why you have a lawyer.
Oh, Ms. Ernst, please, again, this isn't an argument between the two of you to go back and forth. This is
Yes,
my hearing to determine what I need to do to schedule this case so that I can finalize your divorce so that both of you can move on.
If
And
we
you're
could
either going to
schedule
have
as
an
soon as
agreement
possible.
about that or you're not. And if you're not, then we'll figure out a way to get whatever issues there are settled between the two of you.
Certainly. If we could schedule it as soon as possible, that'd be great. I'm worried about defaulting before I can do anything. I can't even get in to show the place right now.
Yeah, I understand. And I will get it on the calendar as quickly as I can.
Thank you.
So, all right. Okay. That's all for today. Thank you. You're both free to disconnect at this time.
thank you.
See the Bonnie Ray Cecilio. All right, ma'am, are you Miss Regal?
Yes, Your Honor.
And sir, you're Tyson Thompson, is that correct?
Yes, Your Honor.
All right, we'll go on the record in that file. That's file number 2514773. The record should reflect that both parties are present today by Zoom video. I have this set today for entry of a final judgment of divorce in this case. Ms. Regal, is that how you wanted to go forward today?
Yes, Your Honor.
And Mr. Thompson, is that how you wanted to proceed as well?
Yes, Your Honor.
Okay. All right. So I'm going to place you both under oath. And I'm going to ask you each a series of questions. The questions that I'm going to be asking you are those that I'm required to ask to establish the grounds for divorce under Michigan law. So if you would please both raise your right hands. You both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes, Your Honor.
Thank you. You can both lower your hands. Ms. Regal, you filed for divorce in this case and you signed that complaint. Is that correct?
Yes, Your Honor.
At the time that you filed for divorce in this case, had you been a resident of the state of Michigan for at least 180 days?
Yes, Your Honor.
Had you been a resident of Kalkaska County for at least 10 days?
Yes, Your Honor.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true at the time that you filed that complaint?
Yes, Your Honor.
Does that remain true today?
Yes, Your Honor.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No, Your Honor.
Are you currently pregnant?
No, Your Honor.
Under the proposed judgment of divorce, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes, Your Honor.
And then in terms of dividing up assets, debts, and property of the marriage, in the proposed judgment that you both submitted, there is a marital settlement agreement that appears to be signed by both of you. Have you reviewed that, and is that in fact your signature, Ms. Regal?
Yes, Your Honor.
And are you asking the court to enter a judgment that divides up the property between the two of you as stated in that settlement document?
Yes, Your Honor.
And by signing that document, does that indicate your agreement to abide by the terms of that?
Yes, Your Honor.
All right, thank you. Mr. Thompson, have you been able to hear all the questions that I asked of Ms. Regal?
Yes, Your Honor.
Were you able to hear all of her answers?
Yes, Your Honor.
Do you have any reason to believe that any of the answers that she gave were untrue?
No, Your Honor.
Under the judgment of divorce, you also would not be receiving any alimony or spousal support. You understand that you would also be waiving that forever and could not come back later and ask the court for that.
Yes, Your Honor.
And then it looks like you've also signed that marital settlement agreement. Is that true?
Yes, Your Honor.
And in signing that agreement, does that indicate your willingness to abide by all the terms of that agreement in terms of dividing up the property and assets and debts of the marriage?
Yes, Your Honor.
Okay. All right, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both the parties. The court will grant the divorce. I'm signing that judgment. That means that your divorce is final as of today. Ms. Regal, did you have any questions at all?
No, Your Honor.
Mr. Thompson, did you have any questions?
No, Your Honor.
Okay, thank you. That's all I have for today, and you're both free to disconnect at this time.
Thank you for your time, Your Honor.
All right, Mr. O'Meara, are you able to hear me okay?
I am, Your Honor. Are you able to hear me?
Yes, thank you. I've got somebody who's logged in under Craig's iPhone. Can you turn on your microphone, please?
Your Honor, my name is Craig Elhart.
Oh, Mr. Elhart, okay. What case are you calling in on, Mr. Elhart?
Clearance worth at 145, Your Honor.
Oh, I didn't realize you were counsel in that. I had it
That's
listed
right.
as both.
Did you take care of it all?
Yeah, I did. Yeah, I had
Good.
them
It
listed
looks
as.
as though I'm useless.
What's that? I'm sorry.
It looks as though I'm useless. That's fine.
Well, you're definitely not useless, but it didn't show. It didn't show you as a counsel for either party, and so that's why I didn't let you in. I didn't realize that was you. Otherwise, I would have let you in. They indicated to me. I guess I'll let you know, the two of them. And I'm not sure how solid it was based on the way the two of them were talking. But they indicated that they had a judgment that Mr. Ernst had signed and that they were ready to go forward with. So I was going to set it for a pro-con hearing at my next available date. But it also sounded like during the course of that hearing, there may be some further discussion that might be had. So you may want to contact your client and the opposing party. And I'll make sure that if you can send in a written appearance, then we can make sure that you're present for the next hearing.
We'll do that. Thank you, Your Honor.
Okay, thank you. Okay, so Mr. O'Meara, I just wanted to make sure that wasn't somebody signing in on this file today. So let's go on the record. This is Dan Woods Properties versus Dennis Dobson. This is file number 2013517. The record should reflect Mr. O'Meara is here present on behalf of Dan Woods Properties, who. Is that correct, Mr. O'Meara? Do I have that right?
That's correct, Your Honor. Sean O'Meara appearing on behalf of plaintiffs.
Okay. Mr. Dobson has not appeared today. I do not see him in the waiting room. I don't see anyone else who's signed in on this file today. So I'm not sure what the status of him or Double D Whitetails in terms of representation. We've adjourned a couple times to give him the opportunity to obtain counsel. But regardless, we're on the record here today for purposes of both a motion on your part for partial summary disposition as well as a status conference. I didn't receive any kind of responsive pleadings to your motion, Mr. O'Mara, but I did have a chance to review it. Do you have anything you'd like to state for purposes of oral argument today?
Your Honor, it's a pretty straightforward motion. It kind of akin to a residential builder not having a license and trying to collect on a contract. Same thing here. Fairly clear that he was not licensed as a broker under the statute. He's trying to collect on. I mean, his attempt to collect on the contract would be void. It's void by public policy. It's actually a misdemeanor that he was committing. So if the court has any questions, I'm happy to answer any. But beyond that, I think the motion and the exhibits kind of stand for themselves.
All right. So again, I did have a chance to review the motion and the supporting documents. In my view, it presents kind of a mixed issue of question and fact and law. So in terms of Mr. Dobson's status at the time of the transaction, and in the absence of any documentary evidence or any kind of filing at all to the contrary, the court finds that there's no question of fact that Mr. Dobson at the time was not licensed, was not a broker recognized by the state of Michigan to buy or sell any kind of livestock, including the elk at issue here. So the court finds that in terms of the factual dispute, there's no factual dispute that he was not properly licensed and wasn't a broker at that time. And so then that leads into the question of law as to whether or not that contract is then enforceable when it was entered into by someone who didn't have legal authority to do what the contract purported to have him do. And I agree with your argument, again, in the absence of any kind of contrary argument or law to oppose that, the court finds that you are entitled to summary disposition on that issue. So the court will grant the relief as requested in the motion. I will ask that you prepare an order and submit that to the court under the 7-day rule. Again, as far as I know, Mr. Dobson isn't represented. So in terms of complying with the court rule and serving the proposed order, if you can just, serve him as you did the motion in this case, and the court will sign that if there's no objection within the 7 days. In terms of how to proceed, I don't know whether you've had any further discussions with Mr. Dobson. Maybe you could just tell me where things are at from your standpoint at this stage.
I have not had any communications with the defendant. I did, mail the motion out to his address and the address of his business. Beyond that, I've had no communication. He did indicate on the record that he was, I believe, retaining and meeting with counsel. And I just assumed that I would get a phone call or something prior to this date of counsel coming in. So I have no idea. I believe he had noticed that he was supposed to be here at a minimum, and he's not.
Right. So I just want to, it looks like the court did serve all parties with notice of the date and time of today's status conference. So I agree. I mean, even outside of the motion, he certainly received notice from the court as to the status conference. So I would just note for the record again that Mr. Dobson or anyone on behalf of Whitetails has not appeared today. So, I guess, Mr. Romero, that could be the basis to request a default in this case. That's going to be up to you as to how you want to proceed.
At this point, I did plan on, as this case I know has been going on for a while, and there's a lot to digest. I think a default, I would request a default as to liability, dismissal of his claims. We would obviously have to have a hearing in sorts as to damages. And I believe actually, I was going to likely be filing, I know, yet another motion probably prior to trial anyway, to delineate the specific loss. And I think we're well on way there. So yeah, at this, I would request a default to the extent that the court would grant that. If not, I likely would be filing another motion. I always hate to do that to judges. I don't like to, I try to, but this one is, this case is, I did come on late, and there has been information that I've obtained since. So we're ready. I feel liability would be established no matter what, as a matter of fact, moving forward. I would request that now. We will be able to, I suppose we could have a hearing or trial as to the damages issue, if that's appropriate, if that's what the court wants to do. I believe you'd be in your right to do so if you wished to do so, I suppose.
So I guess this is the way I see it from a procedural standpoint. Just looking at the file now, I've given Mr. Dobson, I think, since April to obtain new counsel. So in my view, the court's given him more than adequate time to retain a new attorney, to have that attorney make an appearance and begin defending on behalf of Mr. Dobson in terms of the complaint against him and prosecuting his counter complaint. Again, for the record, it does appear he was properly served with the notice of the date and time of today's hearing. In terms of the motion, certainly the court served him with regard to the status conference. He's failed to appear today. So because he essentially has not done anything to move forward with his side of the case since April, I do think that is grounds for entry of a default at this time. So I will do that for the record. I do think that regardless of whether there's a default or not, and you alluded to this, is there's going to be a damages portion of this. So what I would suggest would be appropriate is the filing on your part of a motion for default judgment. And Mr. Dobson would have an opportunity either in pro per or through counsel to appear at that hearing and to challenge whatever it is you're requesting. I do think, because this isn't a case where there's a sum certain that's justified just by a billing amount, or in a typical contract case where there's a sum certain. I think there may be issues outside of that. So whether or not Mr. Dobson appears or counsel on his behalf at that motion for default judgment, I think you would need to be prepared to put on some kind of proofs for the record as to the amount of damages, so that I can enter that. And I think that needs to happen whether or not there is, opposition. So my suggestion would be, and I don't know how much time you would need to do that. I'm not going to certainly not going to advise you on how to do that, or what kind of evidence you would need to present, or in what form. But my suggestion would be for you to make that determination. And then when you get the date and time for the hearing on the motion to enter a default judgment, that you ask my assistant Jennifer to set aside adequate time to do that, more than just a 15-minute hearing like we have set generally on a motion day like this. And if there's opposition, then we may have to extend that hearing out. If there's not opposition, then I would assume that you would request enough time to get the proofs on that you need to get on to justify the judgment. Does that all make sense?
That makes absolute sense. I will prepare two orders, and I will, one on the motion for summary, and then I will also submit the default judgment, and I'll set that for, obviously I'll I'll get some dates from the clerk. I'll set that out, and I will be ready to proceed regardless.
Okay. All right, very good. Anything else that you would like to address for the record today?
Nothing, Your Honor.
Okay, thank you. That's all for today, and you're free to disconnect at this time.
Thank you. Have a great day.
Thank you. Sure. All right. Ma'am, are you Emily Hill?
Yes.
And is that Mr. Hill next to you there?
Yes, it is.
Okay. All right, we'll go on the record in Hill versus Hill. This is file number 2514788. The record should reflect that both parties are present by Zoom video. I have this as a date to enter a judgment of divorce in this case. Miss Hill, is that how you wanted to proceed today?
Yes.
Mr. Hill, did you want to go forward with that as well?
Yes, sir.
Okay. Can you both raise your right hands, please? You both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. You can lower your hands. I'm going to be asking you each series of questions. The questions I'm going to be asking you are those that I'm required to ask to establish the grounds for divorce under Michigan law. Ms. Hill, you filed the complaint for divorce in this case. Is that true?
Yes, it is.
At the time that you filed that, had you been a resident of the state of Michigan for at least 180 days?
Yes, I am. Yes.
Had you been a resident of Kalkaska County for at least 10 days?
Yes.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony had been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true
Yes.
when you filed that complaint?
Yeah.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
No.
Under the judgment of divorce, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and you could not come back later and ask the court for that.
Correct. Yep.
And based on the proposed judgment that you submitted, it looks like you and Mr. Hill are just going to keep whatever property you currently have in your possession, and you'll each be responsible for your own debts. Is that correct?
Yes, that's correct.
And do you own any real estate or real property together?
Not together. He has a house, but my name isn't on it or anything like that.
Okay. Are you claiming any kind of interest in that house?
No, I'm not.
Okay. All right. Mr. Hill, have you heard all the questions that I asked Ms. Hill?
Yes,
Have you heard all of her answers?
yes.
Do you have any reason to believe that any of the answers she gave were untrue?
No, I do not.
And do you agree that the two of you are just going to divide up your own property and that you're going to be responsible for your own debts?
Yes, sir.
All right. And Ms. Hill, you're asking to have your last name changed to Runyon, is that correct?
Yeah.
Okay. All right, so I've signed, the court finds that the statutory grounds for divorce have been met by the testimony of the parties. The court has signed the judgment, so that means it is effective today. Your divorce is final as of today. Ms. Hill, that means that your last name will be legally changed. So you will need to get a copy of this judgment from the clerk's office so that you can change your identification and other documents, okay?
Okay. Is there a certain time frame I have to wait to pick that up, or is it kind of within like next few days?
It'll be ready for you to pick up tomorrow.
Okay.
Do you have any other questions?
Do I just go to the clerks for that, or where do I have to pick that up from?
Yep, just to the clerk's office here in Kalkaska.
Okay, perfect.
Mr. Hill, did you have any questions at all?
No, nope.
Okay, thank you. That's all for today, and you're both free to disconnect at this time.
Okay, thank you, sir.
All right. Let's see. Mr. Hess is connected. Mr. Hess, just 1 minute. It looks like Mr. Boyer's connecting here, so
Okay, yes, sir.
might just take a minute.
I don't know if he's having the same issue I am, but it's storming pretty bad here, so.
Okay. Yeah, it looks like there may be some, might be having some difficulties. It looks like we've got the wheel of doom going here,
Yeah,
so.
my computer just restarted.
Okay, Mr. Boyer's connected now.
Yes,
So
good
we'll go on the
afternoon.
record. Good afternoon. We'll go on the record in Walker versus Northern Springs Management. This is file number 2514752. The record should reflect both counsel are present today. Mr. Boyer on behalf of plaintiff, Mr. Hess on behalf of the defendant. This is the date and time set for a scheduling hearing in this matter. And Mr. Boyer,
Yes.
can you just kind of tell me where things are at from plaintiff's standpoint and what you would like to request in terms of dates going forward?
Certainly, Your Honor. At this time, this case was started like the 1st of April or somewhere thereabouts. And myself and Greg and his office, we have already been in the process of exchanging written discovery. And I believe, if not all written discovery has been exchanged, at least 90% of it has been exchanged so far, interrogatories, documents, requests to produce, and so forth. So now we're getting ready to start with, or would like to get ready to start with depositions. And there's probably quite a few depositions, Judge, because as you may know from the file, my client was a resident of an adult foster care facility and he was left unattended. And as a result of being left unattended, he lost his two lower legs had to be amputated. And so there was a lot of staff members at the facility that will have to be deposed in addition to my client, obviously. So I have talked to Greg and they said that they would like they would like basically 6 months, 180 days to conduct discovery. And I don't have any objections to that if that's what they need. And also we've talked about going to facilitation once the discovery is completed. And Greg gave me the name of an attorney, Matthew Coffey, as a facilitator. I'm not familiar with him. I'm just doing some little background to find out who this gentleman is. But if people say he's a worthwhile facilitator, I probably won't have any objections to using this gentleman. And then we can do a subsequent order to get the facilitation. And we're now coming into, we're in September now. And we probably won't even get a facilitation date until maybe March or so, with the holidays coming up and everything. So and I believe we both want to have the case removed from case evaluation, go to the facilitator, and then hopefully resolve the case. And if not, come back for settlement conferences and or trials.
Okay. All right.
Hopefully I didn't
Mr. Haas?
I covered a lot.
I think you
I didn't
did.
talk too much.
Not at all. Mr. Hess, what's your view?
Yeah, that's pretty much my same opinion. We would ask for 180 days. We do that mostly just so we don't ever have to file a motion to adjourn, because that's a waste of everyone's time if we end up having to do that. We would prefer facilitation over case evaluation, and I guess just for record, say that we reserve the right to an IME. But other than that, I think we're exactly on the same page. Right now, we would like some discovery so we could try to get this hopefully facilitated, and hopefully we can all avoid trial and get this handled.
Okay. All right, so what I'll put in the scheduling order then is discovery to be open for 180 days. I generally order mediation, within the time set aside for discovery. If you need more time than that, that's fine. Just notify the court by stipulation. And I usually don't have a problem as long as it's within a reasonable period of time signing an order extending that for the purposes of mediation. And then I think what we'll do then in this case is I'll set this for another status conference at about that 180-day mark.
Okay.
And that'll give us an opportunity to check in, see where things are at. If you haven't had mediation by then, when it's scheduled and so forth. And then we can also set some deadlines for, cutoffs for dispositive motions and so forth at that point.
Okay.
And then to the extent that it hasn't been settled or resolved in part or fully by dispositive motion, I'll set it for another status conference following that to get trial dates on the calendar. And then we can get the case resolved. So
okay.
What you can both expect to see here shortly is a scheduling order reflecting the dates we've discussed today and a notice of the date and time for that next status conference.
Okay. That sounds good, Judge.
Mr. Boyer, anything else I can address?
I don't think so, Judge. I think you pretty much covered everything else that we need to.
Okay, Mr. Hess?
No, Your Honor, everything's good on my end.
Okay.
Yeah. Judge, it's been a while since I've been in your courtroom. My very first trial with my father, now we're talking over 25 years ago. The trial was in your courtroom on a motorcycle accident case up in Kalkaska.
Well, hopefully, I'm sure you'd like to come back here and see the courtroom again, but hopefully we can get this resolved short of that. But if not, then yeah, you'll have a chance to come back here and see it in person.
That sounds good, Judge.
All right, thank you. That's all I have for today. You're both free to disconnect at this time.
All right, thank you, Your Honor. Thanks,
Thank you,
Greg.
Your
We'll
Honor.
talk, we'll talk later.
All right, if you have any questions, just let me know, Mr.
All right,
Boyer.
sounds good. Bye-bye.
What? Your Honor, I just wanted to introduce myself if I could. I'm kind of new to practice of law, so I'm still trying to meet everyone.
Sure, yeah, absolutely. Nice to meet you. And where is your office located?
We're in Saginaw.
Okay.
So
excellent.
quite a
Well,
ways.
I look
I'm
forward
also
to seeing
new to
you.
Michigan, so I don't even know where this court is, to be honest with you. I moved here last year, so I'm still figuring things out.
Okay, yeah, we're in northern Lower Peninsula, and this is actually one of the few multi-county circuits that we have left. So I have 3 counties in my circuit. So
Okay.
we just like the old days, we travel around as judges here. So, but maybe you'll get an opportunity as part of this case to come up north. It's a beautiful country here.
Yeah, I have no objections. Like, we get a bill for the hour anyway, so I'm like, oh yay. But, no, I just wanted to
All right,
introduce
sounds good.
myself.
Thank you.
Have a good one.
Thank you. All right, the next matter we had was a show cause in Wright versus Weaver. I don't see anybody appearing on that file. So I'm simply going to dismiss the show cause. And if Mr. Elhart's firm needs to refile, they can do that. Our next file is set for 2:45.
without eye strain added to it. That's got me going over jury checks here, so.
All right, looks like we've got everybody connected. So we'll go on the record in the matter of Melanie Sutton et al. Versus Jocelyn. This is file number 2414438. If I could have counsel put your appearances on, starting with plaintiff, please. And I'll need all counsel to unmute. There you go.
Good morning, Your Honor. Shannon Reichert here on behalf of the plaintiff.
Good afternoon, Your Honor. Jacqueline Olson on behalf of defendant Jeffrey Jocelyn.
Good afternoon, Your Honor. Brad Benziger on behalf of K&K Heating and Cooling.
Okay, thank you. We're on the record here today for plaintiff's motion to approve settlement. Mr. Reichert, I did have a chance to review your motion, the proposed order. And typically, when we have a circumstance like this where there's a minor involved, I do have counsel inquire of the proposed conservator, which in this case I believe is Trent's mother, Ms. Sutton. Is that correct?
Actually, Your Honor, the conservator just changed within the last few days. The family decided that it would be better if there were a disinterested party controlling the money given the age of the minor. So the conservator actually is present with us today. Ken, I'm sorry, what was your last name?
Ken Shiner. I'm a local attorney in Gunnersville.
Okay, all right, very good. So, Ms. Reichert, I'll leave it up to you as to whether you want counsel to do that or Ms. Sutton, but just to speak as to the terms of the agreement and the appropriateness of the amount given the injuries in this case.
Okay, I'll just go through and question if you wanted to have someone swear her in.
Yes, Ms. Sutton, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. Mr. Reichert, go ahead and proceed.
Yes, thank you. Hi, Melanie. I'm going to ask you a few questions here. The court just wants to make sure that you understand the terms of the settlement and that you believe that they were fair and that they were in your son's best interest. So if you could please, for the record, state your full name and your relationship to the minor child.
Melanie Sutton. I am the mother of Trent Shepard.
And how old is your son?
He is 14.
Okay, and you understand that we're here today to request court approval of a proposed settlement of your son's claims, correct?
Correct.
Okay, and you've reviewed and discussed the terms of the settlement with your then attorney prior to accepting?
Yes, ma'am.
You had an opportunity to ask her questions and she answered all of those questions?
Yes.
Did you understand the terms of the settlement, including the fact that the litigation costs and the attorney fee and any medical bills or health insurance liens will have to be paid out of the settlement proceeds?
Yes, ma'am.
Okay, and did your then attorney explain the risks and the benefits regarding accepting the settlement as opposed to continuing with the litigation?
Yes.
Okay, so you understood then that settlement is one of several options up to and including taking the case to trial, where you could get a jury verdict that was more than, less than, or nothing at all, correct?
Yes.
Okay, and you believe that the settlement was fair and reasonable under the circumstances?
Yes, ma'am.
Okay, and do you believe that it is in the best interest of the minor Trent Shepard?
Yes, I do.
Okay, and can you please describe for the court your understanding of how the net proceeds for your child will be handled?
That Trent will receive 1/4 of the total settlement, minus the attorney fees and the, like administration fees from the, attorney's office.
Okay, so you said 1/4 or 1/3?
He would receive, if we're just saying for his portion of the settlement, he would.
Understood. I see what you're saying. So 1/4 of the total settlement after. Okay, I understand. But what I actually meant by that question is what's going to happen to his money? What kind of a bank account is it going? Who's going to be in control of it? And when will he be able to?
So his guardian ad litem here in the county that he resides in Marshall County, Alabama, where we reside, his guardian ad litem, Ken Shiner, is his conservator, which was handled through the Marshall County Probate Court and has full approval, and he already has his bond in place, and it will be held in Edward Jones account here in Gunnersville, Alabama, in a interest-bearing account. A safe, I don't know the exact term, but a safe interest-bearing account.
Okay, and then it'll be in place until Mr. Shepherd turns 19, is my understanding?
Yes, in the state of Alabama is 19 years old.
Okay. Okay, and then finally, were you entering into this settlement voluntarily and without any pressure or coercion?
Yes, ma'am.
Okay, I don't have any other questions unless the court does. I do have the paperwork. I received that on, I believe, Thursday or Friday that I could send over to everybody, appointing the new conservator as of a couple days ago. But that part was not included in the motion because that just happened.
All right, Ms. Sutton, I do have a couple questions for you. And again, as your attorney indicated, I have an obligation under the laws of the state of Michigan to make sure that as Trent's mother, that you believe that this is a reasonable compensation for the injury that he suffered. So can you tell me what happened to Trent and whether or not, and to what extent he has long-lasting effects from whatever injury he suffered?
So he had, we all had carbon monoxide poisoning. It was a low levels for a long period of time, a long period of about 3 months. We were just very ill and sick and tired during that time. And, Trent, suffered from memory loss and things like that. It has been now about going on 2 years since the beginning of the exposure, and Trent in the last few months has been doing very well. He does have a 504 plan through his school, and this year Alabama starts school much sooner than Kalkaska does. And we're happy to say that he has straight A's at this moment and not utilizing any of his supports through his education plan at this time.
All right, thank you. Okay, thank you. That answers my questions. Ms. Olson or Mr. Benzinger, do either of you have any additional questions?
No, Your Honor.
I have a few, Your Honor. Ms. Sutton,
Okay,
you
go
understand? Oh, sorry. You understand by asking the court to approve this settlement that you're releasing any and all claims that Trent may have now or after the time he reaches 19, correct?
Yes.
And I don't know if you've seen, I believe your counsel had seen a global release in this matter that is going to be signed if the court does approve the settlement today. Have you seen that?
No, sir, I have not.
Okay. I just want to make sure you understand that you're giving up any and all rights Trent may have, which I think you understand and agree by agreeing to the settlement.
Yes, sir. Yes.
And you also understand that if there are any outstanding liens, subrogation interest, anything like that, that will be your responsibility or Trent's responsibility out of these monies. and that neither you nor Trent will be able to come back to either the named defendants or their carriers to satisfy those things.
Yes, sir.
Okay. And knowing all those things, do you still wish the court to approve the resolution?
Yes, sir.
Okay. That's all I have.
Okay. All right, thank you. Based on the testimony that we've heard today from Ms. Sutton, the court's satisfied that the settlement is in the best interest of Trent. The court will approve the motion and sign that order that was presented. Oh, I'm sorry, we're going to submit a separate order. Is that right, Ms. Reichert, listing the new conservator?
Listing the new conservator, correct.
Okay, so I'm not going to sign the order that was presented, but I will grant the motion and I will sign the revised order once that's presented to the court. Ms. Reichert, anything further that we need to address for the record today?
I don't believe so, no.
Mr. Benzinger?
Nothing, Your Honor.
Ms. Olson?
Nothing here, Your Honor.
All right, thank you. That's all for this hearing today, and all parties are free to disconnect at this time.
Thank you.
Thank you.
Thank you.
All right, and for the record, I didn't click on that case. I thought I did, but apparently I didn't. So I just clicked on it now. So if anybody's looking for a transcript for Shepherd versus Joslin, it's in the preceding 10 to 15 minutes or so. issued by the court, is that correct? So just looking at the file, it does appear that you were not able to get service of Mr. Carl. It looks like the report I have from the sheriff's department is they weren't able to serve him. So we can't go forward with the hearing today until you can get him served. So you may want to talk to the sheriff's department. You may want to reach out to a process server on your own to see if they have more luck. But obviously I can't go forward with the hearing if the other side doesn't know that there's a hearing happening. So I would, since the sheriff's department has already tried, I would try to get a hold of an agency that does process serving. They may be able to get service for you, or contact an attorney's office. They may be able to help you with that as well. And once you're able to get Mr. Carl served, then we can have a hearing on that. Do you have any questions about that?